Hi guys. Look, I've got Robin's phone number at your place, but to be honest, I don't really want to ring up and argue with him because I just don't think that he gets it. I just don't think that he has got the capacity to understand. But that's not really, that's to be expected because a lot of the ministers and the government don't understand or don't want to understand, mainly the Petitions Committee. The Petitions Committee have been using fraud and lying to people so they don't have to publish petitions. They've been saying, we don't know what you're asking for, which is complete tosh. They know what people are asking for. They can understand it. They can completely understand what people are asking for when it's written clearly and people have signed it. Why would someone sign it if they didn't know what they were signing or what someone was asking for? And then the other thing is that they are only allowing links to be put on there, which are government websites. These are cases to the government, cases which need to be proved with either evidence of public support and or evidence of the facts of the case presented. The same as in the Inquiries Act. Part 1, Inquiries Act 2005. Read it. Don't disregard it. Read it. You can have an inquiry based on 1, the facts presented, or 2, the evidence of public concern, which is your signatures. So basically, evidence that people are bothered about it, or based on the actual facts presented. You can have something where you don't have any evidence or any facts, just the fact that people want something, like we want a new park. There might be no case for the new park. You know, there might not be even any, they might not have any children. They might even not have any evidence they've got any children. But if they say, we're the taxpayer, we want a new park because we want one, and 100,000 people sign it, then if they want a park building, it's based purely on the statements, on the evidence of the people, on their concern for wanting one. Whether what they want one for or not. I mean, they might not have any children, but they still might want a park. It's based on purely their will. In the Inquiries Act, you can have an inquiry based solely on the number of people who want it, who are concerned about something, or you might only have one person who presents a case, this has happened or that has happened, and here's evidence that it's serious, and no other people supporting it. It's like any other case. Now, the thing is, these petitions, the whole process is a legal case to the government, like a criminal or civil case, but it has its own proceedings, its own engagement process, which is not through the local courts. If you read, you need to study all of Professor Karen Bowie's Glasgow University paper on the whole process. Whether they have the Lord of the Rolls. They were even trying to charge people for submitting cases. It had to go, at one point they were putting it through the local courts before you could even submit it to Parliament through a local jury or justices, or even through the council. That was all abolished, right? What is the petition? It is a case to the government, a political case, not a criminal or civil case. It is a case. Therefore, anything to do with it is regarded in law of status as a legal proceeding. Now, how do 38 degrees come into that equation when it's a case to the government or a case to the council? It's got nothing to do with 38 degrees. When you bring a criminal case to this government, it goes through the courts, and we have the police. When you bring a civil case to this government, it goes through the courts. Now, you can get lawyers. With the petition, it is a case to the government. Nothing less, nothing more. with evidence, but also with people who support it with their signature statement of support, like in the Inquiries Act. It's the same model. Now, what even are 38 degrees? 38 degrees are acting as a publisher role to publish petitions so people can see them for visibility, to distribute them like the newspaper, and facilitate. Well, that's the same thing. Facilitation stroke publishing role, right? A third party publishing or facilitating the viewing of petition distribution. They're not the government and they're not the person who started it. Now, a petition is like a criminal or civil case. Now, if you need to do any publishing in a civil case or criminal case, when do you publish civil or criminal cases? The police make publications when they need to inform the public. They've got a press office. They issue notices and statements about cases. Issuing notices and informations to the public about cases through the press office. If the person who is engaged in their criminal or civil case needs to publish something about it, like there was a crime or I'm defending myself and I want witnesses to come forward, you publish in the newspaper notices, facilitated notices, distribute material regarding the case and ask people who were witnesses in that town or pub or place who might have information or saw anything to come forward. You are publicising the case in order to get witness statements, signatures, informations to add to the case. That is the role of the newspaper. Now, in the Town and Country Planning Acts 1990 and 2007, right, an advertisement, anything promoting or advertising something which is in connection with petitions, referendums and elections, Class E, and or with the use of an enactment, it clearly states through the use of that law of the enactment, which for petitioning is the right to petition, that all prosecutions and commitments are illegal. And to serve a function, you have to be able to publish for it to function, or people can't see it. It is Class F, and it is completely and totally protected from third-party intervention. Now, a third party are the newspapers who publish it. Now, in the American First Amendment, as well as freedom of speech to walk around and talk, whether you're in public or private, you can speak, whether you're in your own house, someone else's house, in public or private, without being prosecuted or held to any commitment, to facilitate the debate without it being an offence, or without anyone claiming you're harassing them, or any making up any other construed offence by other diverse or arbitrary means, right? They add the freedom of press in the 1700s to add to freedom of speech and freedom to assemble in public and talk about and assemble in public through petitioning, which the 1661 bill grants protection for. It adds freedom of press, to use press in writing, mail, publishing. Why? Because petitions need to be aired. Petitions need to be advertised, promoted, seen, shared. You share them either by a letter, in the post, in the mail. The mail company can't refuse to deliver it. And in the press, public notices. Why? because it is a function of democracy, a democratic function, like sending a letter to a court in the mail. It needs to be sent for a democratic function. There's a legal right. The mail company, now sold off Private Royal Mail, cannot have a policy to say, we will not deliver people's mail. The court are sending letters every day. Why don't Royal Mail say we're not delivering them? Because it's a function of government. A function of government. And through the use of the enactment, secures it to operate, for democracy to operate. Now, when Cameron has sold off BT, Royal Mail and so forth, it wasn't a problem until now. Private companies are taking ownership and they're coming up with insane clauses. Like saying, oh, we don't have to do this or that. One of which is you. Now, you are not any different a role in this, private business or not, than YouTube, Royal Mail or BT. You can't refuse service for something which has a required legal, not only legal right, a legal requirement. It's secured, or democracy can't function whether you own it or not. And that the reason is that you are agreeing to the laws of the realm. We have to agree to the law in the streets, violence, fighting, theft. You can't write a policy in your company where I can murder people in here. I can steal, we can do what we want in our company. This company isn't even have to comply with UK law. It's immune. No, you can't do that. And one of the things, like any other law to enforce, is enforcing these transmissions for function. And now the private companies have taken responsibility. And also, another thing, when you're sending letters backwards and forwards, the confidential, legal letters for criminal cases and civil cases are confidential. It is a legal communication with a legal case. Now, it's true that the petition is published to the public. You publish the petition to the public because you want them to see it. But if you make any communication or contact with an individual that you want to speak to regarding it, and you're not attaching it as evidence, you're just speaking to them about it, it may be like it's a private message or to certain people, that is a letter, right? And what you're doing on your website is you're reading all the letters. You're also intervening in them being sent and controlling who can send and read them. The petition is a legal case to the Parliament, and you're intercepting mail within your website and claiming you've got the right to read mail or even check it. It's actually none of your business. If it's not published on the petition, if it's to someone who's having a petition or another member, it's actually none of your business. Or even if someone wants to send letters to the people who have already signed, and if you were running a petition, you can see all their addresses and you can send any communication to anyone. That's private communication. If it's not published on the petition, you're intervening in it. That's intercepting legal mail. That's another thing that is not questionable, it's illegal. The petitions also, I've already told you this, right? The data, when I create a petition, it's mine. It's my data, and I'm collecting the data. I have full rights to the data. You're the publisher, facilitator. You publish it. You have got a legal obligation to protect my data for me, not from me, for me. Yeah, you were withholding the data from people and also from the local council and government when they were downloading PDFs. And so Change.org doesn't have all the data on. The Petitions and Referendums Local Act 2011 clearly states that the addresses, which means electrical or physical address, whichever you've been given, every page of the petition and every copy that anyone is authorised to have, and really the person who created it has a copy and the person who it's addressed to has a copy. They're really the only full copies. A copy has to be complete with the full data. Otherwise, you can't check the data. Now, you're a publisher facilitator. It is not actually your legal right or responsibility to check any petition data or information or signatures. It's actually the local council or government, or whether it's McDonald's you're sending it to, who it's addressed to. You've got to prove to them that the signatures are legitimate, or it's their responsibility to check. In Atlanta at the moment, and this is really, really important, they've got some ridiculous rules in Georgia which are questionable anyway over petitioning. Like you've got to have witnesses and it's got to be signed by hand and all these other things, which in the Tumultuous Petitioning Act, it clearly states that you can have verbal consents to petitions as well. You can't be held to any of these ridiculous processes and procedures. This is why they were charging people for petitions, and they put a stop to it. So they couldn't charge or make up ridiculous rules or conditions. That was ended with the 1688 bill because it was regarded as subversion of the liberties and freedoms of the realm. That's what was happening through the Tumultuous Act. And the Tumultuous Act clearly had got set out that the only legal actions in regards to petitions, prosecutions and so forth were brought by the King's Bench as assizes. Now, it was abolished with the 1688 Act because prosecutions are illegal by the King's Bench. You can't be intervened in. And it doesn't go to a local court because it's not a case to a local court. It's not a criminal or civil case to a local court about something. It's a case to government. So it's not intervened in by local courts. This is the thing with Extinction Rebellion and Just Stop Oil now, which I'm trying to get Jonathan and Fuller to understand, and I think he does. Even Max Hill, the director of public prosecutions, who's now stepped down, they prosecuted Angela Ditchfield for criminal damage for painting Extinction Rebellion on a wall because they wanted to get a criminal damage charge. They wanted to secure a criminal damage charge against her. They wanted to do her and make her a criminal. Yet, they completely and totally ignored the existence of two entire acts of law, not only explicitly and specifically enacted and created to deal with not only advertisements and notices in public and defining the advertisements in public and what they are, words, letters, signs or representations, but further to that, the statutory instrument, the 2007 one, which adds to the definitions in the 1990 Act, creates specific process and procedure which exempts it creates classes of material, and class E and F are political material through use of the enactment. And you don't need consent, express or deemed consent. Both sections, which any other advertiser, any other person putting notices in public, any other entity giving notice needs to get express or deemed consent. There's two entire sections in the Act. The Class F is automatically exempt from requiring permissions because you're using the enactment. You don't need permission. The law gives you permission. The law gives consent. And in the classes, there is a specific class of advert, which is Class C, which is painting on walls, which is all provided for doing which it created a class. And usually you need consent. But you can use multiple classes where applicable. Class C and F together, you're using the enactment of a Class E and F advert for referendums and petitions through use of the enactment, which has a legal requirement to be distributed, and if you're painting it on a wall, it's Class C. Now, even if that's challengeable, it's challengeable through that law because that is the law that deals with it. And if you didn't have consent or the right, there are certain punishments for breaking those laws in that act. So why didn't Max Hill and the police chiefs take legal action against Angela Ditchfield through those acts with appropriate punishments? Why did they bring a criminal damages charge when it's not an offence? It's specifically because when they recognise those acts and say these acts are which it's legislated through, what she was doing is legislated through those acts and the 1688 bill, they have to recognise that it's Class F, and that the reason is a Class F, and that the reason is a Class C, and the reason is a legal argument, and the reason is a use of an enactment. And therefore, they can't bring criminal damage charge. Even if they did do it for something, it would be through the Town and Country Planning Act and statutory instruments, which means they're completely and totally undermining the law of England. This is a Chief Crown Prosecutor and the Attorney Generals. They're undermining the law of England. This is what we're up against. Police chiefs, right? And you aren't helping. You're meant to be, we love petitioning. We are meant to be helping everyone in England do petitioning. We're all about petitions and all about free rights. Where is the assistance with this? Where is the challenge? Robert F. Kennedy Jr. is the only person, Marianne Williamson, who are challenging this establishment, not only in America, but globally. And they've got monkeys like you running these businesses and companies now, with a big smile on the face because they're like running over revenue, ticking over and doing well for themselves. Yet you're doing well in undermining our rights and liberties. You're doing well in completely misunderstanding petitions and being misled by Parliament because they don't want us to have the rights. Same with Angela. We're being infiltrated. Now, you don't get to have policies on petitioning. Not where rights are in place. Policies where you are safeguarding our information and safeguarding our data, not withholding it from us, not intervening and not obstructing. In America, they've got 501c3, illegal campaign intervention law. You are facilitating and publishing a material for a legal case to government. You don't have a right of intervention. You don't have a right of obstruction, and you don't have a right to read private legal mail regarding those cases or intervene in private legal mail concerning those cases. You wanted to have a petition website. It publishes petitions and facilitates them so people can see them. It is someone's legal case, someone's evidence in proceedings. They're trying information. Now, when it comes to the content, right? In a criminal case, you get evidence, you get fingerprints, you get material. No one knows whether it's right or wrong, true or false. Ultimately, you're trying the information to the court. You're trying to convince the jury and judge that it is the truth. If you couldn't submit it, they wouldn't be able to see it and decide. You don't have a newspaper looking at it and then saying, oh, all right, we agree with this. Now you can, this is it. If someone steals a painting and you've got a criminal case, and I go to the newspaper to publish a notice that the painting's been stolen, and I have I have the right to copy the painting, because people need to see what it looks like. If anyone's got a photograph of it, Black Belt Barrister, and Alan would say on YouTube, the lawyers would say that, you can't even you're not really supposed to be taking photographs of and publishing photographs of paintings if you didn't paint the painting. If you bought the painting, you own the painting, but you can't reproduce it, right? In a legal case, it's a legal requirement for evidence. You need to publish the painting to ask anyone if they've seen it. If they've seen it anywhere. Have you seen this painting? So you need to make copies of it in the newspapers. It might be 500,000 copies. If you're putting notices out, you got copyright exemption. The newspaper cannot actually refuse publication, because for the legal case to function as a functioning legal framework, you need to be able to ask witnesses to come forward, and you've got the right to. That is where 38 Degrees are. You are the newspaper. You are like YouTube, publishing videos, or a radio station. It is a third-party facilitation of publishing, right? And it is a legal sector which the publisher is restricted on their actions, and like the telephone company, they cannot refuse certain communications. Now, if someone hasn't paid the bill, that's different. You're paying for the line, the service. What I speak to someone on a telephone about is not the telephone company's business. What I write to someone in Timbuktu about is not the Royal Mail's business. I pay for if I don't pay them, they won't deliver anything. And for legal letters, we pay for it. We've already paid for it. Tax money pays for it. And the fines. It's all paid for when they're sending to us. And also, and even if you win the legal case, you can claim expenses back, which includes travel and stamps. So you claim it back. If you win the legal case, you can claim back for letters and stamps and things like that if you put in for it. That's the point. Because, if you were innocent, the state has prosecuted you on behalf of the people, and you're innocent, you don't have to pay for the stamps or travel to court. You claim, you fill all that in. You don't even really know what you are doing. Really, there is a whole area of government, for example, with the tampon tax petition, they won the case, and they got the legislation put through. They could claim they could claim expenses if they wanted to try. No one's trying, or at least get the VAT and tax back, which is what I was looking to get back from the newspaper in publishing my petition notices. And as for the information, it's a case. You're trying to prove something. I'm trying to prove something through information, and if the public think it's true or not. 38 Degrees, it's not your case. I'm trying to prove the case to Parliament or the Council, and when I submit it, they judge it. 38 Degrees are not the government. I looked at 38 Degrees. It's not a charity or democratic society either organisation. It's maybe run as a business. It's not actually acting on behalf of or as a department of HM government. 38 Degrees is not registered as a department of HM government or a committee. Therefore, he has no authority to judge any accuracy of information or material in any petition. And then further to that, the signatures, when you walk door to door, you can get 500 people to sign. You do not know what they're writing on that paper, if it's true or not, unless you ask them for ID every time, unless you look at the door number. What if they're at their friend's house? You can't know. It's impossible to know whether they're lying or telling the truth in their address until you check it. In Atlanta, this has been the case. All of the citizens who have been collecting signatures, they've got to prove to the town, to the council, that they're all legitimate. Now, if the council and town check them when they're handed in, and only so many of them are legitimate, the rest are discounted. Only the legitimate ones count. Any ones that aren't legitimate or have got wrong or false data do not spoil or ruin the case. They're set aside, like in elections. Now, all of the citizens who are helping are currently checking all the signatures that they've gathered on a database. But they don't have to check them. They don't have to. They want to. They want to check them, so they've got an idea of how many are going to be valid versus how many are not going to be valid. Because the ones that aren't going to be valid are likely going to be rejected by the council when it's counted by the council and verified by the council. They're volunteering to count and check them just so they've got an idea of all of the signatures they've collected which are going to be valid. Because even they, when they collected them in person, by hand, none online, none. Even when they collect them themselves face to face, they've got no idea of whether the other person is writing the truth or fact down, whether the signature's right, whether the postcodes are correct, whether the address is correct. I have been going on Signal app. They've got a group in Signal app. The group is scanning all their signatures into a computer and checking them with the electoral register to match them. And some don't match. Some they can't match. Some people aren't even registered to vote in the area. They cannot. You can't control another person who's signing something. You don't own them. You're not responsible for their behaviour. It's like in crime. Now, when I am asking someone to collect signatures for me, it's not under my control. And when I check petitions on 38 Degrees, I can't see those signatures. So I cannot check them. I don't have actually any, and even if they're not valid, so what? When I hand them into the council, it will be dud. Now, if they count, we pay the council in taxes, and they've got a petitions committee. They're meant to have facilities, staff that we've paid for to check all this. Now, if 38 Degrees are saying that, 38 Degrees are taking over the role of the council and government, and they're going to check it all for them. What are we paying the council and government for? What are we paying as taxes for? Are you telling me that now the government and parliament are contracting out petition checking and even judging to 38 Degrees, but why hand it into the council? If 38 Degrees are judging all the petitions' information to be correct or not, then why send it into the council? 38 Degrees is not the government. They are a publisher and distributor of petitions. And that is the role. You're not a department of government. There is actually no third-party right of intervention in a case to a government. A civil, criminal or political case to government, there is zero third-party right at all whatsoever. You've got the right to run a business and publish, and there actually isn't a right to refuse for petitions because it's guaranteed under the rights and freedoms of the liberty that we actually have a requirement to publish. And on the Parliament website, it says that it's a direction from Parliament to share and use Facebook, Twitter, and other platforms and emails. So they're giving you a direction, and that direction is also facilitated for in the law. If you read the Act, it says through an enactment direction. So you just don't actually really know what a petition is. It's not some sort of flimsy process where you've just got a right to walk up to people and ask them something and write something down and hand it in. It's an entire framework. There's no doubt that 38 Degrees are taking it seriously, but they're taking it seriously in the completely wrong way. The completely opposite way. They're saying, this is really, really serious, so we've got to intervene and safeguard it. No! This is really, really serious that you haven't got the right to intervene in. You have to safeguard people's right to do it. You've got to safeguard their right to not have you intervene. And you've got to safeguard their data and protect their data. You wanted to have a petition platform. You want to share and distribute petitions. Now, there is responsibility with that, but not a serious responsibility of, you stopping people. Oh, this is really serious, therefore, we've got to stop you doing this, we've got to intervene with that, we've got to have a policy. No, it's so serious that you cannot do this. You cannot do that. You cannot intervene in this. You cannot read those messages. You cannot do that. This is what you chose to do. We want to have a petition website. And seeing as I've had those petitions stolen and all my evidence, of which I don't have other copies, is compiled into a case, that your website actually, even though it's not the government, it's like the Small Claims Court. When you go into the Small Claims Court and you upload evidence to the court, when you are a third party and you are not a court and not the government, but people are running casework through you, you can't intervene in it. You can't actually intervene in the case. And when you pay lawyers, you're paying a lawyer to help you. 38 Degrees needs some serious study in petitioning. And it's not just that. YouTube have been getting it wrong. And Robert F. Kennedy has pulled them up on it and challenged them on it. And we're pulling them up on the First Amendment, on the freedom of the press. It's our right of use of the press. And that the reflection of that is in that clause from the Town and Country Planning Acts, which states where there is a legal requirement to publish. That is the equivalent of the clause in the First Amendment. Because what else is it about? It's three clauses which are in the Constitution of America in order for facilitation and function of government, which is the right to petition it and speak about it and publish in order for it to function. It's nothing to do with the press as an organisation and the newspapers, the right to tell people stories and stuff like that. It's for democratic function. It's the right of you access to press and publishing for function of government, and that is the same as the clause. It's the freedom of press in the First Amendment is the same as that clause in the Town and Country Planning Act and statutory instruments. That is it, and that is the clause which applies to 38 degrees, because you're publishing the material and there's a legal requirement to do it and a right to without intervention. So you need to update. And as I've been stolen of 7 or 8 months of the petition, you can also promote it for free for 7 months, or both of the ones that were taken down, or all 3 of them. The Pond Lane one and the Lepton Woods one and the one for our ancient site for Castle Hill for Camberdenham, because you've taken 7 months away unlawfully. I am not responsible for who signs it or the data, because it's beyond my control. It does not throw the case. Bad signatures are set aside, and any information tried in a case which is found to be untrue is simply voided, like in a criminal case. You're trying to prove something. If we already know whether it was true or false or not, why would you be bringing the case? If you already knew, this is what they're doing with fines. They're making people admit it so they don't have to go to court. They're admitting guilt so they don't have to prove anything. You know, it's all automatic. We're having the legal system taken away from us, and private entities are taking over. And 38 degrees is right behind it, on the side of the opposition. You're not on the side of freedom and liberty. You're not on the side of democracy. You're not on the side of the right to petition. You're actually helping completely and totally hijack it from the public and hand it over on a plate to the corporate sector, and they make decisions, and they're running the country now through policy of private business, which is what David Cameron's sold off everything. Why are you helping Cameron to steal our country? Why are 38 degrees trying to be the government, not challenge the government? 38 degrees aren't the government. We're challenging the government through legal cases.